Hi, my name is Steve Appel from Work Comp Matters, and thanks for joining us for another episode. This week on Work Comp Matters, there is no news. This week on Work Comp Matters, there is no ancillary stories. We've got the best of the best as my special guest on the show. Attorney, applicant attorney, extraordinary in workers' compensation, Mr. Michael Burgis, talking about his personal life, his business life, and the business of workers' compensation. All of that plus John Scalia on this edition of Work Comp Matters. And now, here's the show.
Stand by SOT1.
Standing.
10 seconds. Ready, rollin'. Ready, SOT1.
Ready.
In 4, 3, 2, 1. Roll in.
From the round table at Uncle Studios in beautiful Southern California, welcome to another edition of Work Comp Matters, the central location for you employees, you employers, and of course, you independent contractors. My name is Steve Appel, and I'll be your host for the next hour with some talk, some news, and hopefully some answers about Work Comp Matters. Thanks for being part of the show, and if you can break away from your Work Comp Matters, feel free to give us a call and clue us in. Questions, comments, and or concerns. The phone number worldwide, 818-357-4120. You can send an email to WC Examiner. Heck, you can be old school. Send me a fax, 818-475-1437. With me in studio, the Chief of Staff, my right-hand man, Dr. Mike Zyma, applicant attorney extraordinaire, Michael Burgis, the best-dressed man in Southern California work comp, Ted Durden. On the board, taking care of the technical difficulties, Scott Walton of Uncle Studio. Back in Munich, Germany, John Scalia. And back at WorkCom Central, making sure the whole damn thing goes right, is Ms. Kristen Chavez. Well, good evening, everybody, and welcome to another edition of Work Comp Matters. This is going to be special. We're going to be doing some things that we have never done before. First, we have decided to dispense with the news. There is no news tonight, and one of the reasons is our guest, and I'm going to introduce him in just a moment. Firstly, of course, Work Comp Matters is brought to you by A1 Law. If you want the number one computer management system used by more workers' compensation attorneys than any other system in the damn Kuiper Belt, give me a call, 818-357-4120 for your no-strings-attached money-back guarantee, $1 a day, A1 Law. And if you want those hard-to-get sold-out, even front-row concert, sports, theater tickets, give my buddy Brian a call at Santa Monica Tickets, 310-395-8587. And last but not least, here's a little something from ABC Rugs. ABC Rugs has been in the business of manufacturing and direct importation and exportation of Persian and Oriental rugs for more than 39 years. ABC Rugs is a direct importer and wholesaler of antique, Moroccan, Oriental, and Persian rugs. Established in 1978, ABC Rugs is definitely old school. 323-897-5444. That's ABC Rugs. 323-897-5444. And there goes ABC Rugs. Also want to give a shout out and a thank you. Coming on the show next week, President and CEO of Work Comp Central, Kristen Chavez, will be live at the round table at Uncle's Studio. As you all know, I had lunch with her, and we talked about whether or not Work Comp Central would continue with the contract, and maybe she'll announce it. I don't know, but she's coming in, and that's going to be wonderful. But that's looking a week ahead. Tonight, we are off the charts, and I'm going to introduce my guest now. He was born and raised in Southern California and earned his BS degree in economics with a minor in political science from UCLA in 2003. He graduated from Southwestern Law School in 2008, passed the California bar, Folks never looked back. His career began in California workers' compensation with Glauber Berenson, a well-known and respected workers' compensation law firm, where he stayed for 5 years until he decided to hang his own shingle. He now has 2 offices, give or take about 20 employees and or 20 people working for him, and is one of the most respected workers' compensation attorneys in the entire state of California. He has obtained multiple 7-figure settlements, multiple $100 100% disability awards for his clients, and has successfully argued before the California Court of Appeals. It is my privilege and my pleasure to welcome to Work Comp Matters attorney Michael Burgis. Hey, how you doing?
Thank you for that wonderful introduction, Steve. I appreciate all of that, and I'm glad to be here.
It's my pleasure. How do you like legendary Uncle Studios? It's nice to stretch out and relax, huh?
And it's very close to my office, which is very wonderful. I might have to be a frequent guest here.
I was just going to say, if we treat you right, and I will do everything to make that happen, I'm sure we would love to have you back. What we're going to do is we're going to do the first half of the show just like we do the normal radio show. And then for the second half of the show after Scalia, we're going to do a couple of video segments within the radio show, which we've actually never done before. So the people that are listening to the radio podcast, they're going to hear it before the videos come out, and the videos are going to be sort of instructional. So whether or not you're a work comp specialist, if you're a seasoned practitioner of law, you're going to enjoy the first part of the show. The second half will be somewhat instructional, so if you want a brief review or whatnot like that, or if you just want some information, please feel free and listen. If you like Work Comp Matters, subscribe, hit us up on Facebook, tell your friends, whatnot like that. So firstly, I have to get this off my chest. I have a total bias. I got to tell you that I have a man crush on you, dude. You and me, I want some bromance. And I think we've only known each other for a couple of years, and it was earlier in the year that I asked you to be on the show, and, you weren't rude or anything, but it was just, well, I'm busy, you're busy, we'll let you know. And then I really didn't follow up, but I know we spent about 5 minutes, just talking about cases and what's going on and stuff like that. And then a judge who will remain nameless, who we both know, he has told me many times, get Burgis on the show, get Burgis on the show. So he told me this one last time. I said, I'm going to call him right now. I call you up on the phone, you break away from what you're doing. Not only do you say you're going to be on the show, we spoke for about 20 minutes about just different stuff, and I'm going, this dude is hot. This dude is an animal. He has got some takes, man. He is going to make for some great radio. And now you are here at the round table. So, as always, I try and get both sides across. So now that I got all the positive, before I really ask you questions, do you know who Kong P is? I'm assuming you don't. Okay.
I don't.
Okay. I do my best to do my research.
Sure.
Kong P, about 2 months, put a review of Michael Burgis on the internet. Jared, the IT guy, would refer to him as the hater or a troll or something like that. So
I know who this is now.
Okay. You've got about 45, 50 reviews. This is probably the worst review you can get. You don't mind if I read it to you?
Sure, go for it.
Okay, very good. And again, here we go. So it's by Kong P. Poor service. Do not choose this law office. They don't return calls or emails. Michael Burgis is arrogant and only cares how he looks on paper and on camera. They will settle your case, but will not put much effort into it. They totally ripped me off in my cases because they want to make the other side's attorneys look good and happy rather than get you the money you deserve. His employees in the office are just plain dumb and have bad customer service skills. Oh, and Mike, and this is where, in my mind, he crosses the line.
He hasn't crossed the line yet? All right.
Michael Burgis's wife, who works there and is his partner, is a moron and will represent you poorly and unprofessionally. Now, before you comment, let's just speak for a moment about your wife. graduated with honors from the School of Business from the Marshall School of Business, USC, went to Southwestern Law School, law review, top 20% of her class, and graduated from the bar. Mike, I mean, she must be an idiot, right?
Oh, yeah, she certainly sounds like an idiot. Yeah,
Let me also add that I have never met a more brilliant legal writer than my wife. My wife was Cal-Lead Legal Writing in my law school. She is a huge part of
What is that? I'm sorry, Cal-Lead Legal Writing? What is that?
That means you got the highest grade in the whole law school in legal writing. She is and ironically, English wasn't her first language, and she is a phenomenal, brilliant writer, and a big part of our firm's civil success is hugely attributed to her writing. And I will also tell you that this Kong P, or whatever his name was, I did a lot of research to track down this gentleman. One, I don't think he's a client of mine, or I don't think he ever was a client of mine.
See, I knew it was a troll, but go ahead.
It's definitely a troll. When you beat a lot of defense attorneys at trial, you probably make some enemies, or maybe it's a competitor. I don't know. But
I'm sorry, what is a troll?
A troll is someone who goes to comment on the internet specifically for negative criticism.
To injure somebody.
Right, yeah. See, they don't know anything about the person that they're speaking about. They may just gather a little information to make it seem as if it's believable.
And I will tell you that, one, I quickly ascertained that this was not a client of mine, nor is that a valid critique in any way. My wife hasn't worked for the firm for about 4 years now, and he was indicating that she was working on the case. She hasn't worked for 4 years. Since
His comment was from October of this year.
Yeah, so my wife, we have a beautiful daughter, and she hasn't worked for about a year before that, and so she's not litigated any cases, not worked for my office. It's all complete nonsense.
Well,
I even tracked down this gentleman left only negative reviews, as most trolls would,
Right.
and I tracked down those other facilities, called those facilities to see if they can find it, and none of them could ascertain that this was a legitimate person. I'm currently working with Yelp to take it down, but it's a bit of a...
That's not going to happen. There's a Supreme Court case about that you cannot compel Yelp to take down good or bad comments. You, of course, have the remedy to sue the people that left the comments if it's disparaging or...
Well, it sounds defamatory, but how can you identify the defendant?
Well, yeah, the culprit.
So ultimately, I have got some Yelp reviews removed. It was not an easy task. In fact, it was a Herculean task. And one of the ways you can do it is by showing it's a fraudulent review by a competitor, which I'm currently working on. So flashback a few months from now and see if it's still on there.
There you go. Now, I was going to say, the criticism that you don't return calls, it's got to be impossible. I mean, we have a 72-hour callback policy in our office where we will schedule a meeting either on the phone or in person.
But it's rare that it goes 72 hours.
Yeah, normally we can do it within 48. Do you have a callback policy in your office?
I have a 24-hour callback policy. Everyone can get a call back within 24 hours. I make myself available to each and every one of my clients. They could come meet with me personally, regardless of whom the coordinator or who the handling attorney is for my office.
Now, as far as settling cases cheaply or whatever, just to make yourself look good, you're on a no recovery, no fee, at least in workers' comp. Obviously, you're working to get your client as much money as possible, because the more money you get your client, the more money you get your office.
Of course. My firm does workers' comp, we do catastrophic PI, and we do employment, wrongful termination, retaliation, discrimination. Everything we do 100% on a contingent basis. I front all costs for absolutely everything. My clients never pay a dime, and I make a percentage on the back end. So, of course, I'm highly motivated to get the greatest overall recovery for my clients.
And as quickly as possible. If you're going to put all that money out, you're not earning interest on it. You want it back ASAP.
And Steve, since you brought up Yelp really quick, let me just say
sure,
one thing here. Yelp I have probably hundreds of positive Yelp reviews that are not recommended and are hidden from the page. And of that is my very favorite Yelp review, which is a gentleman that worked for Caltech, NASA, and a few other agencies that we can't disclose, who is one of the smartest people I've ever met in my entire life. Indicated on Yelp that I was the smartest person he had ever met. So my all-time favorite Yelp review is not flagged and actually hidden. So I recommend some of those listeners that want to see some of those Yelp reviews to go to the hidden ones as well.
Now, really quickly, and you mentioned your wife. I was married for 11 and a half years. I've been divorced for close to 17. I could never work in the same office as my wife. You said it's been a couple of years. What was it like working with your wife, and did you ever have to take that home with you?
So, Steve, first off, I had the foresight to realize that I would never be able to have a long-term working relationship with my wife if she was physically in my office. So while my wife did do substantial work for the firm, she always worked from home, and she never had an office actually physically in my office. We wanted to keep sort of a separation that is healthy for our relationship.
Excellent.
Yep.
And does she control all the money?
She controls the household.
Okay, so she controls the household, and you
Yes.
control the business. That's an excellent relationship.
Yes.
I think that's great.
And I'm grateful. By the way, taking care of a household and a daughter is a full-time job, and I'm very appreciative of that.
Absolutely. Now, as I said earlier, I have a bias, and I've been running some stats. I may even have some information that you might not know. I found that you have about 28 to 30 YouTube instructional videos out there, which have about 250,000 hits. Now, your first one, which is like a minute, has like 750,000. So it's got 75,000. It's got a third of that. But I calculated that out. And essentially, we're looking at 250,000 hits by 200 minutes. You have approximately 1,250 hits for every minute of video that you have out there. If you compare that to me, I've got 100 audio shows that have about 6,000 minutes. I've got 10,000 hits. So compared to your 1,250 hits a minute, I've got about 2 hits per minute. So once again, I am so glad you're here. I'm looking forward to the videos later because I know it's going to be much better for me than it is for you. Okay.
Well, Steve, wait till you see what I got going for 2019. You know,
That's okay. Keep talking.
Those YouTube videos started out with me just, a little 1080p camera and just talking about the law. One of the things I pride myself in my law firm and dealing with my clients is I pride myself in my clients actually understanding the law, knowing what it is I can and can't do for them. I want to establish reasonable expectations at the beginning so they really know what we're up against. But so I created these videos to help alleviate some of the stress and ignorance of workers' comp. And it started with just a little 1080p camera, and I just hit record and did a little bit of videos. And wait till you see what I have planned in 2019, because I have a huge barrage of very good educational videos and a vlog, which is including getting transcribed into a blog and then transferred into Spanish blog as well.
You said a vlog?
Yes.
What is a vlog?
A video blog.
A video blog. Got it.
So Google bought out YouTube. YouTube is now the biggest search engine as far as I know. So I'm really heavily getting into those videos. And 2019 is going to be the production quality is going to move up a whole bunch.
Are you going to have a studio?
I pretty much built a studio in my office already, so I have it built in. Yeah.
That's great. That's great. Now, you spent about 5 years working for Glauber Berenson. Tell me what went into the thought process to hang your own shingle.
First off, I'll start off by saying I'm still friends with Russ and Jamie, and I'm very grateful for everything I learned over there. Ultimately, I learned so much at that firm, and I'm very grateful for everybody there. They're pretty much like a second family. But what really was in my thought process when I left is Russ has worked very hard and Jamie's worked very hard to build their empire. No matter what, it was always going to probably be me working for Russ in some capacity. And I'm a surfer also. And, when I just remember thinking, there's a big set of waves if I'm, partnered up with Russ and Jamie or working for them. It would be me still stuck there, holding down the fort. And I wanted that autonomy to be able to go do the things I enjoy and love. And everybody wants to run a firm a little bit differently. And there's so much good at that firm. And I just thought to myself, if I could take a similar business model and put my own unique touches and differences, it just seemed to be the right choice for me. I was never planning on working for somebody long term. So I pretty much straight out of law school knew I was going to go out on my own.
Now, I have to infer or presume that during the 5 years you brought in clients, and then I presume when you left you had to have taken some clients. Is that accurate?
Sort of.
And let me not say take. Clients transferred from where you were to where your own office.
So I had, about the time I left, I probably had a caseload of like 400 cases, something around that regard. When I left, I think I took maybe a handful of cases. I strongly believed in starting my own shop fresh on my own, not burning bridges. I was very grateful for what Russ and Jamie did. So I think I took maybe 6 cases out of 400 cases that I had, and those 6 cases were 3 of them that were my personal friends and my personal referrals. So they were clearly would have been very upset if I left them. In fact, some of which I actually left there, still left with them. And the only other 2 I took were cases that I had already tried, already got 100% disability. Glauber Berenson got the full fee on that. And they were just so upset when I told them I was leaving, that we had built such a rapport together that they were basically going to follow me regardless of whether I wanted to do it or not.
What do you mean? What do you mean follow you?
Meaning they were going to harass me to the point I took them anyways.
Oh, okay.
And I'll tell you, as a show of my appreciation from what Russ and Jamie did, one of them was a case that a catastrophic stroke that I ended up giving oral arguments in front of the Court of Appeals.
You gave them back some of the fee.
I gave them all the fee, but not only that, I responded to the Supreme Court on my own and didn't take any of that fee. So I was very grateful for everything they did. So I try to be as stand-up as I possibly could, and still hope to do so.
When you opened up your new office, how many people started with you? I mean, one secretary, one paralegal, or what?
So when I started, it was literally just me. And then I don't know if you guys are familiar with Jesse Marino, but he's a applicant attorney that I very much have come to love and respect. And I worked out a deal with him so that I bought out his Valley practice. He had both an office in the Valley and an office down in Santa Ana. So
did you coordinate that with day one of the opening?
Yes.
There you go.
Yes, of course. So during the time I was discussing and really in the crossroads of whether I was going to decide to have a very long-term relationship with Russ and Jamie and Glauber Berenson, or whether I was going to go out on my own. I actually, ironically, when I was giving oral arguments in front of the Court of Appeals is when I really met Jesse Marino. He heard about that case and came and listened to me give oral arguments and approached me afterwards. And there he propositioned me to form a partnership. And then I convinced him to just sell me his Valley office. And it's been very symbiotic for both Jesse and I.
And now you just recently, you added on a second floor to that Valley office. You also opened up a Chino office, right?
Yes.
And you have about 20 employees now, give or take?
Decent amount more than that, and I'm growing pretty fast here.
Okay.
But
do you fear expanding too large too quickly?
My wife does, but I do not.
Okay.
Yes, my wife would like me to curtail a little bit of the expansion, but I ultimately want to expand to one other location, and then once I do that, I think I'd probably be happy with those 3 offices in Southern California for the time being.
That's great. Talk a little bit about your hiring and firing practices. What do you look for when you hire a secretary, an assistant, or an attorney?
Great question, and I will tell you that somebody I very respect on the business side of things gave me a bit of advice. This is coming from a 75-year-old gentleman who was very successful in his career, and he told me, fire fast, hire slow.
Fire fast, hire slow. Okay.
And it's good advice.
Yeah.
I look for
Mike, write that down. I like that.
I look for the it factor. I look for it to me.
Now that's not the wow factor, the it factor.
It's the it factor.
Okay.
So let me explain. I almost don't care. I mean, experience is very important, and of course, if somebody's coming in with a decade of experience, that's important. But if I got somebody who's just a hardworking hustler, very motivated, disciplined, I'll take that guy with no experience over somebody with 20 years experience. So I really look for somebody who I think just has the it factor. And I think, you can see it in an interview, and those are the people who are like, listen, take a risk on me, take a chance on me. I'll work my ass off. I will do whatever's needed, and you can tell very quickly, within the first month if that's a good hire or not. So I've been very fortunate that I've found a lot of very good employees in random locations that have been with me and have grown with me. And I rather train from the ground floor up than bring somebody in, at a lateral position, for the most part.
Talk about your firing practices.
I'm very proud of this fact, but I've been out on my own for over 6 years. I've really never had to fire anybody, and I've never had anybody leave.
Congratulations. It says a lot about you that you treat your people right. I read where you said that education is your best investment. Not that I disagree, but I've always said the people that work around me or the people in my office are my best investment.
I agree. I'll tell you that my business model is to compete with Google for the coolest place to work.
All right.
Because the amount of money I invest into my employees, the time, the training, I bring doctors in. I invest so heavily in the training of my staff and the development of my staff to become rock stars, if they're not rock stars already, that if one of those people left me for the defense side for like a $10,000 raise, I would take a huge loss. So my business model literally is to compete with the coolest place in the world to work. And let me just give you an example of what my firm does that I'm unaware of other firms that do this. Well, in addition to paying full medical, full dental, setting up a 401k that goes live January 1st, I pay ridiculous salaries, ridiculous bonuses that are all proportional. So I'm a big statistics guy, okay? And I will tell you that one of my issues with my prior firm, or working for any firm regardless, is the work didn't stress me out. What stressed me out, or what I didn't like, was that conversation with my boss about salary every year. If I'm breaking every record and producing money, I don't care how old I am.
You're on your knees begging for 3%.
And I just I couldn't stand that. It's like, hey, you're only a 1-year attorney. Hey, you're only a 2-year attorney. I don't care if I'm a 1-year attorney or a 20-year attorney. If I'm breaking every record, period, I should be paid proportional to my services.
Absolutely.
So, and I'm really looking for a business model where I can expand. And the way I can really do this is I've essentially created a formula, a transparent formula, where all my staff knows the variables. So one, I use A1 case management.
A1 Law.
And
there you go.
I have a little plug there.
Thank you for saying that. Thank you.
I input a lot of data into A1, and I'm able to extrapolate that into a whole bunch of Excel spreadsheets.
Most people that use A1 only use about 10 to 15% of its functionality. Obviously, you use considerably more.
Of course. So ultimately, my office is set up that there's a paralegal or coordinator on the staff, and there's an attorney on the staff, and then I oversee everything. And there I can keep stats on what coordinators, how long it takes them to prepare a case for settlement, how long it settles. So I can, through A1 and through my Excel spreadsheets, I can come up with the revenue that the attorney or coordinator is producing, how long it takes them, what their average settlement is, what the average settlement time is. I discount all of that stuff for present value, and I can literally have mathematically who should be paid what without any ambiguity. And I don't care if you're male, I don't care if you're female, I don't care if you're young, I don't care if you're old, I don't care if you have experience.
If you're bringing in the money, that's the bottom line.
Exactly. And because I have this system in place, I'll never have that awkward conversation about salary, because they all know the variables and they know what's going on. And I will tell you that I would be highly shocked if there was a firm that paid higher than I do, or was just a more enjoyable place to work. I also have a full employee lounge with an ice cream machine, a ridiculous cappuccino machine, a gym. I have a personal trainer that comes in and trains my staff. We go above and beyond to make sure that all the staff is taken care of, because there's so much stress dealing with this BS work comp system.
And we're going to get to that in the second half of the show.
We don't have to add any of that stress from a management standpoint.
I have a few more questions for you about you and your personal business. We're then going to go to John Scalia. Then we'll come back in the second half of the show and talk about work comp issues. You were talking about putting money into the business. I don't expect you to tell me how much, but is there a percentage of the business that you put into advertising? A percentage of the business gross revenue, net profit, or do you do advertising? Or
last year I put in over $1 million in advertising.
So you are one of those guys that's putting in basically $100,000 a month into advertising. Got it.
I am, and next year it's going to be even more. But the fortunate thing is that because the firm is growing and expanding, I will tell you that I'm only doing that for a limited time.
Yeah.
The reason why I'm doing that is I need to get my base clients in, because the truth is the best form of advertising is to just take care of your clients.
Right.
You take care of your clients. For every one client you take care of, they're going to send you 7 over their lifetime. And I'm so fortunate because I'm getting to the point now in a very short period of time that the vast majority of my clients are referrals from old clients, and I'm getting to the point where I don't need to spend that money, but I'm spending that money heavily now to build my base.
It's an investment in your future as well as the people that you work for. I was going to say, what is the mobile recovery vehicle? I mean, I saw a picture of it, but go ahead and tell everybody what the mobile recovery vehicle is.
Okay. We call them MRVs, and I'll tell you that that's going to be one of my video campaigns coming out in 2019, and I'll air it live for the first time because I haven't really told too many people about this.
Okay.
But one of my business models is I hate advertising directly to injured workers. To me, it has this air of not sleaziness or desperation,
ambulance chasing.
It's the guy in the back of the bus. Who I potentially I just don't want to do that. And so what I want to do is I want to get the firm out into the public without directly soliciting. And there's other ways to do it. So I have a few interesting ones, and one is on the MRV campaign. So I have a fleet of these electric vehicles we call MRVs, mobile recovery vehicles. And my staff drives those, to and from court, wherever they need to go. We can go sign up a client. A lot of times these, severe injuries, that it's very difficult for them to come to you, so we can come to them. So I have these mobile recovery vehicles, tastefully wrapped, nothing cheesy with
vehicles. How many do you have?
I have 7 right now, and I'm actually in talks to there's Chevy Volts right now.
Yep.
We're trying to go electric for hybrid purposes and the economic impact. And so I am now in talks to get a whole fleet of the Teslas coming up, which I'm looking to expand.
The 35s?
Yes,
yeah,
exactly.
Okay, yeah.
Now, and the cool thing is, in the campaign I'm going to do shortly here is called the Catch a MRV. So what I'm trying to do is, if you see a MRV in the wild, out in the streets, 1 mile away from our office or court system, so you can't just camp out. But if you catch one of these in the wild, take a picture, share it to social media with the hashtag Burgis Law or Recovery for the Injured. You can hashtag the charity of your choice, and for every picture that gets shared, we're going to donate $100 to the charity that person chooses. The one that gets liked and shared the most that month, we're donating $1,000, and I'm going to keep doing this until I can't afford to do it.
That is absolutely wonderful. Yeah. I got one more category to talk to you about, and then we're going to go to Scalia, and then we'll come back and talk about specific issues in workers' compensation. In my research, you are what I would classify as a thrill seeker. Okay, firstly, you do funky stuffs on bikes, dirt bike riding, jumps and twists and all that stuff. Like you said earlier in the show, you did surfing. Now, what I wanted to confirm, do you do skydiving or sky parachuting or something like that too?
I've pretty much done everything. I've skydived, gone hang gliding, bungee jumped, surf, ski, mountain bike, pretty much anything, raced motorcycles. Anything I could do to harm myself, I've probably done it.
Okay. Your office has Laker tickets?
My office goes to lots of Laker games, Kings
you go
games,
to
Dodger
lots
games.
of Laker games?
I do. I'm a Lakers fan too.
Okay. And last but not least, I don't know what you have. You have a couple of cars, but you like muscle cars and or sport cars. I know specifically I saw on Facebook you like GTO and split rear window Corvette.
So I'm a car enthusiast. I like new cars, and I have a special love for classic cars and muscle cars. I have a 59 Apache Fleetside surf truck that is an absolute ridiculous truck, and it'll be in SEMA next year. It's got.
Is it a Woody?
It has a wood bed, but no, that truck was originally supposed to be my beater surf truck. I just wanted a cool classic truck to go to the beach and back, and it has morphed into an absolute ridiculous twin turboed V8 on airbags thing that I didn't intend in the beginning. But I have a slight problem with cars and stuff like that. Split window Corvette 63 is my next dream car. It's not a GTO, but I have a 66 Malibu Chevelle, which looks a lot like the GTO. The race engine was built like a block down here from the studios.
My brother Mike used to have a 68 Chevelle Malibu, if and when the next time you speak to him. He had a 68 Malibu.
I love it. I can talk cars all day long. My wife drives a AMG 63 G-Wagon, but it's been custom tuned by a company called Rentec. Probably the fastest G-Wagon out in the streets, period. And that's what she's rolling around in. I love cars. I love tinkering on cars. So that's just one of my hobbies.
My name is Steve Appel. You're tuned into Work Comp Matters. We're talking with applicant attorney extraordinaire Michael Burgis, but it's time to go to Germany for his regular segment on Work Comp Matters, and then we will be back. John Scalia.
Hi, this is John with the Work Comp International Report from Munich. Well, there's two big events on the continent this week. One are the civil disturbances or riots in Paris. However, that is an evolving process, and there's been no resolution as of yet. Emmanuel Macron is talking to union leaders, so that situation's in flux. The other event, which is also somewhat in flux, is the exit of Great Britain from the European Union. I've watched a lot of what's going on in the British Parliament on BBC television, and I can tell you that what's going on in the British Parliament is the greatest comedy act since Monty Python out of Britain. But aside from that comment, what is actually happening? Well, Britain is leaving the EU and is by law has to leave the European Union at the end of March 2019. Britain has been a member of the EU for 45 years, so this is obviously a complicated process. Theresa May, the Prime Minister of Britain, negotiated a tentative deal with the EU, which she brought back to Parliament for their approval. There was widespread dissatisfaction with the agreement, and it was unlikely that it was going to be approved. In fact, today was the day that the Parliament was supposed to have a vote on whether or not to accept the deal. And yesterday, Theresa May went to Parliament and said, the deal's not going to pass, so I'm canceling the vote, and I'm going to run off to Brussels and see if they can't tell me something that's going to change your minds. Well, good luck with that. But anyway, what has been the main stumbling block in the deal? The main stumbling block is a place called Northern Ireland. Now, Northern Ireland is another country from Ireland, theoretically. Well, in reality, it really is. But if you look at a map, you will notice that Northern Ireland is on the island of Ireland. It's part of the country. But it's a separate part of the country, a separate country. And for 20 years in Northern Ireland, there were what was referred to as the Troubles. That is a euphemistic British way of saying civil war. And it went on for 20 years with lots of explosions, lots of killing, et cetera, and was finally concluded by a peace agreement on Good Friday, 1998. The accord, which was actually negotiated by an American, is called the Good Friday Accord. And as a result of that peace agreement, the warring factions in Northern Ireland agreed to constitute a government in which they both would take part. There was only one main political party in Northern Ireland which refused to accept the agreement and was against the agreement. They preferred to have the killing going on. That party was called the Democratic Unionist Party. Interestingly enough, that party is now an ally of Theresa May in Great Britain. In fact, after the snap election, in which she did very poorly, she did not have a majority. So in order to get a majority, she made a deal with the Democratic Unionist Party. She gave Northern Ireland an extra $1 billion, and the DUP, Democratic Unionist Party, agreed to vote with her on issues. However, there's cracks in the union right now. Okay, what is the problem with the agreement she negotiated with the EU? Well, the problem is very simple. The problem is Northern Ireland is another country. So if you have a country that is not part of the EU and an EU country next to each other, that border is like most borders between estranged countries. In other words, there's going to be border guards, there's going to be customs checks, there's going to be visas required, et cetera, et cetera. But Northern Ireland cannot have that because that might bring back the Civil War. So they want to have a soft border. The soft border is what has existed since the Good Friday Accord. In other words, you can drive from the Republic of Ireland into Northern Ireland today just like you're driving down any street. People live in one of the countries and work in the other and go back and forth daily. No problems. But once Britain exits the EU, there's this border problem. So the agreement was, well, if we have to, and if we can't figure out any other way, we'll go to a backstop deal. The backstop, without getting into technicalities, essentially treats Northern Ireland slightly differently than the rest of Britain in terms of its relation with the EU. This is unacceptable to the Democratic Unionist Party, which, as I indicated, are a bunch of fanatics who prefer to have the killing going on rather than the peace treaty. But they're what Theresa May needs to constitute her majority in the British Parliament. So she's flying off to Brussels this week to see if she can't get them to say something nice, which is going to get anybody to change their mind in the British Parliament. That probably ain't going to happen. Here's what probably will happen. 1, the deal will be voted down, so there will be no deal. 2, there will be a new prime minister after that happens. And 3, there may or may not be a new referendum on whether Britain stays in the EU. Those are the most likely outcomes. In the meantime, the circus goes on. Well, that's the view from Munich this week.
All right, John, and as always, thanks a lot. My name is Steve Appel. You're listening to WorkCom Matters. We're brought to you by A1 Law, Santa Monica Tickets, and, of course, ABC Rugs. Well, we're going to try something completely new here for the second half of the show. You, radio podcast listening audience, will get this about 2 days after we do it, and we'll see what happens with the video thing that we're doing for the first time. So, Scott, when you're ready with the intro. Welcome to WorkComp Matters Video, where experts on the front lines talk about the issues of the day for employees, employers, and independent contractors. WorkComp Matters Video is brought to you by A1 Law, the #1 computer management system used by more workers' compensation attorneys than any other system on the planet. And now, here's your host, Steve Appel. And thank you very much, and welcome to WorkComp Matters Videos, where the experts come in and talk on this show. Applicant attorney in workers' compensation extraordinaire Michael Burgis is coming in this show to talk about how workers' compensation and employment law overlap and all of those intricacies. So, Michael, welcome to the show, and go ahead and take it away.
Thank you for having me, Steve, and pleasure to be your first on your video segment here.
It's a pleasure. Thank you very much.
I got some virginity, huh? Okay. So I just wanted to briefly touch bases a little bit about the overlap between workers' comp and employment law practices. You know, we use this phrase inextricably intertwined a lot in our workers' comp practice, and it fits perfectly with the combination of an employment law case and a workers' comp case.
Mike, when the doctors say inextricably intertwined, are they really saying, I have no friggin' idea?
I take the position, well, it depends. Sometimes that is what they're saying because they're not sharp enough to understand this, but no. Hopefully what they mean is they are doing an analysis. They have to address both apportionment to non-industrial and industrial, but they also, of the industrial apportionment, they need to see if they can separate that amongst the dates of injury. You know what, now that you brought this up, before I go into employment, let's talk a little bit about inextricably intertwined for a second.
And I got to tell you, I don't know if you caught the new case, the city of Petaluma, but it specifically mentions SWAG, scientific wild-eyed guess, which is wild-ass guess, which is in the labor code. But please, go ahead, take it away.
Well, first off, I will just say, if it was a SWAG or a wild-ass guess, ultimately, apportionment is defendant's burden, and I take the position that they don't meet their burden. Applicants entitled to unapportioned award, including an unbensonized award. But we mentioned a specific judge earlier, wondering if he's listening to this or will listen to this. But ultimately, I wanted to bring up this case because the case is called Jerry DeLeva versus Northrop Grumman. Judge Pollack out of Van Nuys was the Honorable WCJ that issued this opinion, but it's a very important case, and I want to briefly talk about that. I would depose a doctor, and hypothetically the doctor's giving a lot of impairment and he splits it 50-50 amongst 2 dates of injury, and the doctor's like, well Mike, why are you fighting me so hard on this Benson apportionment issue? I said it's all industrial. I don't think the doctors or a lot of people in the community truly understand the severe monetary impacts on Benson apportionment. So hypothetically, you got 2 10% cases. Let's say that's roughly about $7,000 in PD. So if a doctor says you have 20% disability and it's on 1 date of injury, or if he says you have 20% disability 50-50 split on 2 dates of injury, that's not one 20% award, it's 2 10% awards, and that drastically reduces the monetary value. Now, when you start looking at extreme examples, look at a 100% case. As the viewers or listeners may or may not know, 0% disability to 99% ability is a relatively small amount of money per month or per week.
And it's scheduled. It's a specific dollar amount.
Yes. So 0% to 69%, it's a finite amount of money. Once those weeks of payments are paid out, that's it. Above 70 to 99%. The greater your disability is, the longer the duration of those payments, but then a life pension will kick in, which is still a pretty de minimis amount of money, adjusted with cost of living adjustment, but it's still de minimis. The true way to get substantial justice and high monetary awards in workers' comp is 100% disability cases, although those are getting harder and harder to get nowadays.
Which is payable at the TD rate for the rest of your life.
Yes. So if you have somebody who's 100% disabled, unable to compete in the open labor market, or not amenable to vocational rehabilitation, and a doctor finds that solely attributed to 1 date of injury, that's 2/3 of your salary for your rest of your life. Now, if that's
tax-free.
Now, if that doctor were to say, wait a minute, there's 2 specific injuries, it's 50-50 split, that becomes 2 50% awards, which, let's just say for argument's sake, that's about $120,000, whereas the 100% disability could be 1.5, 2 million, So Benson apportionment has drastic effects for injured workers. And I was a part of a case wherein I took over a case from Charles Rondeau. He had agreed on an AME and there was considerable disability, but the Dr. Benson apportioned it, said 50% to this one, 25-25. Didn't even explain how or why. And per Gatton, I didn't believe that was substantial medical evidence. But regardless, there was a psych and an internal that were compensable and found that the injuries were inextricably intertwined. That is, they weren't saying they couldn't do it. They were saying that it's impossible, it's inheritively speculative to apportion to a reasonable degree of medical probability. They weren't saying they couldn't do it. They were saying they are making an apportionment determination and it's inextricably intertwined. This is important because in the labor code, if a doctor says they can't make an apportionment determination, in the labor code it says they shall consult with another physician. And litigating this case, including up in front of the WCAB, I took the position is, no, they don't have to consult with another physician because they are making an affirmative determination that it's inextricably intertwined. But I tried this case and ultimately I had the case settled and they backed out a couple days before trial. I was arguing that my client was entitled to a life pension award, which meant above 70% in disability. And ultimately my position was, one, the agreed medical examiner's orthopedically wasn't substantial on his Benson apportionment determination, but irrespective, even if it was, because the psych and the internist are inextricably intertwined, you can't apportion, mathematically it just doesn't work. And when that happens, the defense doesn't meet their burden. An applicant, as a matter of law, is entitled to unapportioned award on 1 date of injury, which frankly is just sort of makes sense with justice and logic. I tried this case in front of Judge Pollack. We did some briefing on this. Judge Pollack issued a decision awarding a life pension and basically saying that he thought the AME's Benson apportionment determination was substantial, but it wouldn't matter because the internist and the psychs are inextricably intertwined, and as a matter of law, unapportioned award. Of course, the defendant reconned this case and went up to the WCAB. They put a stay on the case for about 8 months, and we did multiple briefing back and forth. ultimately, Jerry DeLeva versus Northrop Grumman is a case that come down. It's a noteworthy panel decision. It's not an en banc decision. I don't think there was enough justices on the bench at the time. But ultimately, this case now stands for the proposition that you could have 10 AMEs, and 9 out of 10 could do proper Benson apportionment analysis, but if one finds it inextricably intertwined, the applicant is entitled to unapportioned award. That's a really, really big case for injured workers, and the judge did the right decision on this one. The WCAB affirmed it correctly. There was a justice that dissented, but the judge that dissented basically said, well, I don't think they explained inextricably intertwined well enough. So I do agree with your contention that some of these doctors do just say inextricably intertwined because they don't know and they can't explain it. And I want to talk to all the applicant attorneys out there that are listening that if a doctor says inextricably intertwined, you haven't won your case. Sure, it's a magic word, but they need to explain how and why it's inextricably intertwined. And, let me give you an example that I've used a few times. And the defense position in this case on the supplemental briefing to the WCAB was, hey, the psych is a compensable consequence of the ortho, so is the internal. So they should just flow in line from the orthopedic Benson apportionment. The problem is that's not accurate, and there's case law that's come out subsequently saying that they can't do that because it's a separate apportionment analysis. The psychologist has a separate apportionment analysis than the orthopedist, even though the psych may be a compensable consequence from the ortho. Here's the example I like to use. Let's say you have somebody with a neck injury, and let's say that ultimately their neck injury is rated based upon range of motion. Let's say they have significant bilateral radiculopathy, multi-disc involvement, whatever. It's properly rated range of motion, but they had 2 specific injuries. They had one injury that caused significant range of motion loss, and then another date of injury that caused much more range of motion loss. Now, ultimately, that may be a case where the orthopedic AME may be able to do proper Benson apportionment. If there was basically a PNS report or range of motion studies showing that they lost X amount prior to the subsequent injury, and now the subsequent injury has caused an additional amount, that's just math. The total range of motion loss, do the math, you can break that down apportionment-wise, and I think that might be valid Benson apportionment. The problem is, if the psych is a compensable consequence, it shouldn't follow directly in line. Here's the example. Let's say that he had range of motion loss, but the applicant, hypothetical applicant, had range of motion loss to the neck from the first date of injury, but it wasn't severe. It was significant, but it wasn't severe. He could still see over his shoulder. He could still drive. It affected his ADLs, but wasn't hugely disabling.
Activities of daily living. Please continue.
Yes. And let's say that the second injury is what caused a significant increase in his range of motion, but now he can't even see over his blind spot. Now he can't drive. Now he's homebound. Now he becomes wildly depressed and anxious. And so if you look at that example, that last date of injury may be the sole injury that caused the psychiatric disability, because maybe the psychiatric injury and disability didn't occur from the first range of motion loss. Maybe it was that last tip that put him over the edge. So, or maybe it's a combination, but you can't say what percentage is what. So ultimately, I think that the case law is very strong in this regard, and that a consulting physician that finds injury and disability as a compensable consequence of an ortho can't defer and shouldn't defer because it's a separate apportionment analysis. But I will also say that, I can't see how any psychologist or internist, for that matter, it's inheritively speculative to apportion amongst the multiple dates of injury, absent objective evidence from all of that pre-existing injury, comparing it to the subsequent injury. Inextricably intertwined is legitimate, and it's real. And if you get them to explain how or why, I personally think it should be upheld, because it is what it is.
You've been listening and watching my guest, applicant attorney Michael Burgis, on this episode of Work Comp Matters Videos. We've been talking about apportionment and inextricably intertwined and swag, special wild-ass guesses. For my guest, Michael Burgis, on Work on Matters Videos, my name is Steve Appel. And, of course, for the radio audience, that is scientific wild-eyed guess. And now I'm going to redo the opening in 3, 2. Scott, don't worry, I'll just do it. In 3, 2, 1. Thank you for joining us for another edition of Work Comp Matters videos, where experts in the field on the front lines come in to talk about issues regarding workers' compensation, employment, and labor law. This week we have with us applicant attorney extraordinaire Michael Burgis, and we'll be talking about apportionment. So for the radio audience, we continue on. Now we're going to do a brand new segment on the video. And Mike, did you say you wanted to do about the overlap between workers' compensation, employment, and labor?
Sure. I just had a lot of appellate work across my desk on an employment law issue that's fresh in my mind. So sure, let's talk about that.
Hang on. And Jared, you're ready? And Scott, we're still running. So here we go in 3, 2, 1. Welcome to another edition of Work Comp Matters videos, where we have experts in the field of workers' compensation, employment, and labor law come in and briefly talk about workers' compensation, employment, and labor law. We're brought to you by A1 Law, the #1 computer management system in workers' compensation. And now, without further ado, talking about the overlap between workers' compensation, employment, and labor, applicant attorney extraordinaire, Mr. Michael Burgis. Hello, Michael. It's a pleasure to see you.
Thank you, Steve. Thank you for the introduction.
Thank you.
So off air, we were talking a little bit about employment law, and I just want to discuss a little bit about that with the viewers or listeners. First off, employment law and workers' comp, very synergistic. I would use the phrase inextricably intertwined. And I will say for the listeners who are in the work comp industry, if you don't fully understand employment law, I think you might be doing some injustice to your client unknowingly. So I want to briefly just state what the position I
think the classic example is in a workers' comp case, agreeing to a resignation when you do a compromise and release, because therefore, and Michael, you tell me, you foreclose all of your rights you have towards an employment lawsuit. Is that correct?
You hit one of the biggest nails on the head. This is something that makes me discuss it. I will be at the WCAB, and I will hear people left and right sign voluntary resignations. And it kind of sickens me a little bit, and I'll explain why that is such a bad thing, and I will put it into some real-world examples of cases I've litigated. So first off, remember that in employment law, a quick synopsis is when an employer has knowledge that one of their employees is injured, whether it's work-related or not is irrelevant. But whenever an employer has knowledge that one of their employees is injured or has disability, they have a legal obligation. Okay, I'm an employer. I find out one of my employees is injured. My legal obligation is I need to engage in an individual interactive process, and I need to figure out what's going on. And I'm legally obligated to make all reasonable accommodations so long as it doesn't represent a quote-unquote undue burden on me. Now, let's talk about that for a second. We all handle workers' comp cases, or a lot of us here handle workers' comp cases. They report injury, discrimination, retaliation, failing to engage in that interactive process, failing to make reasonable accommodations. I would say this happens more often than not. And I will tell you that I rarely see an employer do everything correctly. So ultimately what happens is this. Let's say a workers' comp case is filed, litigated, and ultimately settles by CNR. What happens is the applicant attorney will ultimately sign settlement documents, and in there is inevitably a voluntary resignation. For the viewers and listeners, almost all defendants are going to want that, and actually rightfully so. The employer wants, and the carrier wants to make sure that if they're going to buy out the future medical in a compromise and release, they want to make sure they're off the hook and they're off their exposure. And as we know, while permanent disability may be apportionable, future medical is not. So if you were to CNR a case, buy out the future medical, be done, but that client was still working for the same employer.
There starts his day one of his new CT.
Exactly. And assuming they're still insured by the same insurer, if they're not going to care about a voluntary resignation. But if that's the case, all they have to do is aggravate any of those injuries by 1%, and it's a relatively easy burden to prove. Then the insurer's back on the hook for the money they literally just paid out on the CNR. So I don't fault the defendants for requesting these or wanting this. The issue here is the verbiage in the quote-unquote voluntary resignation. One, it should never be a voluntary resignation. And it should never say that the person is voluntarily resigning.
What I do on my cases is I very much encourage the defense attorney to recommend to his client something to the effect of the parties have agreed to an employment separation. That way it doesn't say he resigned, quit, or anything. It's a separation of employment. What's your take on that?
That's exactly what you should do. It should be called a separation agreement, and it should just simply say, I, applicant, am not working and will no longer seek rehire. Now, if you say, I am not working and will no longer seek rehire, that contractually gives everything the carrier that they need. He's not working. He's not going to seek rehire. They're off the exposure. Okay, but saying that I'm not currently working and I'm no longer seeking rehire, nothing in there is voluntarily resigning. You're not. The problem is whenever you voluntarily resign, you are cutting off all damages from a potential employment law, wrongful termination, retaliation, failure to engage in the interactive process. So you got to be very careful about that. And then one of the other issues is. So once again, an employer is legally obligated to engage in an individual interactive process. They're legally obligated to make all reasonable accommodations unless it represents an undue burden on the employer. Now, what's going to happen is if you go to file that civil lawsuit or somebody else is filing that civil lawsuit and you've just signed a voluntary resignation, you're going to get a pretty upset phone call from that plaintiff's attorney saying you just cut off all damages. And that plaintiff's attorney, if they know what they're doing, they're going to tell their client to find a malpractice, professional malpractice, and sue you. And this is the one area in workers' comp where you can actually get hit for malpractice fairly easily. And it's in all those addendums, those general release language. Any addendums in a settlement, don't sign general release, don't allow any of that language in.
The dastardly 1542 clause, I think it is.
Yeah. But let's talk about.
Well, actually, if you don't mind, when we were off
Sure.
camera, you were talking about specifically temporary disability or TD and overlap between workers' comp and employment.
And let me. That's a great transition. So let me discuss that for a second. How often do you see this? You see an injured worker who gets probably wrongfully terminated, goes to a physician, and this physician feels bad for this person, knows that they have a legitimate case, knows that they probably just got wrongfully terminated. And so what does that physician do? They say, you know what, I'm going to help this guy out and I'm going to find this person TTD so they can get EDD benefits. That is a potential significant problem in an employment law case.
Well, first off, it's fraud if it's not true, but go ahead.
Agreed. So one, I will tell any applicant attorney or employment law attorney that's listening to this, one, I agree that's fraud because the doctor should never find somebody temporarily disabled if they're not. But two, remember if there's temporary work restrictions and the employer's not accommodating, they're legally entitled to TTD regardless.
Which is, for those of you that don't know, is temporarily partially disabled, TPD.
Yes, but they're whether they're TPD, they're still entitled to total temporary
They're entitled
disability.
to 100% of temporary disability benefits because you cannot apportion temporary disability.
Exactly. So ultimately here, and I'll give you an example of a case. This is a case that I've been litigating for 5 years now, and it has. I haven't even heard of a case that's been litigated more than this, but and I could speak openly about this case and fact pattern because it's a public decision. The case is called Noe Arbarca versus Citizens for Humanity Gene Company. Okay, 7 for All Mankind, Citizens for Humanity. This is a very fancy gene company that a lot of people have these genes. They're very expensive. My own personal opinion is you should never buy these genes. It's a shady company. That's my two cents here. But my client, Noe Barca, hardworking Hispanic gentleman, working for this company for about 6 years. All he does is lift boxes, take them out to the QA department, pass them out to the girls who inspect it, and then when he's passed out of the boxes, he inspects his box. He's working for, 3-4 years, starts to get a shoulder pain. Mind you, he's repetitively lifting boxes on a daily basis, full-time plus overtime. His boss says, well, Noe, you can't work. You don't have a job. Clearly didn't engage in an individual interactive process, clearly didn't attempt to make reasonable accommodations, in fact, threatened him. So it's retaliatory and discriminatory. But this poor gentleman, Spanish speaker, sucked it up, worked for like another year. Finally, the pain is so unbearable, he goes to his boss and actually goes to the HR department and says, hey, my shoulder's really bad, I need to see a doctor. They say, go to your personal doctor. clearly what they should have done is it's obvious that this is potentially a work-related claim. They should have provided a claim form. They didn't do any of that stuff. And he goes and sees a doctor. The doctor gives work restrictions of like no lifting more than 15 to 20 pounds for 30 days. He takes this into his employer, and I could tell you that his employer right then said, we need to get rid of this guy. But what do? Oh, he has work restrictions for 30 days. Everybody thinks that, if they terminate him there, they're in trouble. So they wait one business day after the work restrictions end, and they let him go. And they say, work slowed down. Okay? They bring him in. He's begging for his job, and they're saying, nope, you got to sign this. We're letting you go. And he's begging for his job, and then he finally says, well, what about my shoulder? I need to see a doctor. And they say, I'm sorry, are you reporting a work-related injury for the very first time after you've been told you've been terminated? And so for our viewers, there's something called a post-termination defense. And that is, post-termination defense is a proper and good thing because we shouldn't have people who are disgruntled and filing BS work comp cases because they're disgruntled. So if you file a workers' comp claim after have knowledge of termination, you're going to lose unless you can show that you reported it previously, that you treated for it previously, or there's the CT exception that you didn't really know there wasn't a concurrence of injury and disability with sufficient knowledge. But so what are they trying to do? They're trying to set up a BS post-termination defense. And so they make him sign in Spanish, I am for the first time reporting a work-related claim after I've been told I've been terminated, before he gets his check. And then they deny the case and they fight me to the death on that. The funny thing is, there's a spot on that claim form right above that says employer's first date of knowledge. They put that date. He turned in work restrictions 30 days before. Definitively, we could prove that the employer was lying. So this is a case that I handled both the workers' comp case and I've litigated the wrongful termination case, including doing a month-long jury trial where I went against one of the most elite defense firms on the planet with an extremely high win ratio, and they basically tried to paper me to death. Motions for summary judgment, 1 million motions in limine. They deposed everyone and their mom, 8-hour videos videotaped, hired 1 million experts to combat mine. In fact, they hired John Stahlberg as their expert to counteract Dr. Neharayan's testimony about the wrongful termination causing stress, depression, and anxiety. So ultimately, on this case, I could clearly show, in my opinion, that he was wrongfully terminated, retaliated, and discriminated. And so we did a full-on jury trial. And I'll say one bit here for the viewers is that individual employment law cases are very difficult. They're very litigious. They cost a lot of money. But I will tell you that there is a huge propensity to get monetary justice for your clients in civil that we don't see in the workers' comp arena. And that is, you can get pain, you can get suffering, you can get full lost wages, and you ready for this? You can get punitive damages. And so I will tell you that I came up with a little theory on this case, and it worked. Okay, so remember that punitive damages in the civil arena, you have to show that the defendant acted with malice, oppression, or fraud. But you have to show that it was the owner of the company or a managing agent that made or ratified the decision. So of course, what happened in Noe Barca's case, they claimed later their position was he was a horrible worker. We terminated him for being a horrible worker for good cause. They said, one, we did engage in an individual active process. Two, we didn't have to make reasonable accommodation because the box he lifted were under 20 pounds, which was absurd. Then they said, we fired him for good cause. And but even if we did anything wrong, two big defenses. His primary treating physician found him totally temporarily disabled. So even if we did act illegally, there are no damages because the damages in the employment law cases, but for their illegal action, but for their failure to engage in the individual interactive process, but for their failure to make reasonable accommodations, but for their wrongful termination, retaliation, discrimination, he would have continued to work. Those are the economic damages. And they're saying, but the doctor found him totally temporarily disabled. So it bars any economic claims. Then they said, and ultimately it was a low-level supervisor that made the decision, so we can't be on the hook for punitive damages. Now, I will tell you what I did there is I sent a letter to the employer saying to the managing agent, hey, please conduct a good faith investigation. I think my client was wrongfully terminated. take them back. So they're legally obligated to take that investigation. And what I did at trials, I put the managing agent on the stand. And I said, listen, you know all the facts. You conducted an investigation. Still think you did everything right? So at that point, he can only do one of two things. He could admit fault, and then we just won liability at trial. Or he says, no, we did everything right. And what do you think he's going to do? He's going to say he did everything right. And then the next question you're going to say, so you're ratifying the decision of that low-level employee. What can you do? When you go into jury instructions, literally the question is, did the employer failure to engage in the individual interactive process? Did they fail to make reasonable accommodations? Did they wrongfully terminate, retaliate in violation of public policy? There's a whole jury instructions. And then one of the questions will say, did defendant act with malice, oppression, and fraud? And I will assert to you in any employment law case, yes, that's of course what they're doing. Then the next question is, did a managing agent make or ratify the decision? You just did it at trial. And then on a very small case, by the way, this case, I did a 998 for $150,000. And for the viewers who don't know what a 998 is, it's basically saying, hey, here's my most reasonable demand. Pay me this and we're done. But if I go to trial and win $1 more,
yeah.
You're going to win. You're going to have to pay all of my expert costs. And so I tried to come up with the most reasonable number for my client that I thought was adequate. Now, my client was a minimum wage worker, had something that happened subsequent to his wrongful termination that took him out of the workforce, so I had very small economic damages. The jury awarded $100 in compensatory damages, but then awarded $550 in punitive damages. And here's the kicker that I want the viewers and listeners to, you get statutory attorney fees under FEHA if you win a cause of action under FEHA. So if you can show the employer failure to engage in the individual interactive process, failed to make reasonable accommodations, retaliated or discriminated, you get statutory attorney fees on top of your percentage.
And now all you need, if I'm not mistaken, are at least 5 employees for it to qualify for FEHA, correct?
Yes, and I'll tell you that determining, I'll tell you right now, if you have a very small employer, you should be very hesitant to file employment law cases because, one, the smaller the employer is, the more likely it actually is an undue burden on them to make reasonable accommodations.
And two, if you win a big suit, they're probably going to go bankrupt, go out of business, and they won't be able to pay you anything.
There you go. That's you can't get blood from a stone. And I will tell you then also, if you're going real big, punitive damages, remember what they're designed to do. They're designed to do two things: punish and deter.
Right.
And in order for that to happen, it needs to sting. So what happens if you get punitive damages, you go into phase 2 of your trial. Your jury's going to hate you because your jury's thought they were done. But then they go into phase 2 where you put the financials of the company on the stand and then you basically pitch the jury. Listen, if you give $100,000 in punitive damages to a company whose gross revenue is $10 billion, do you think they're going to feel that? Do you think that's going to punish them? Do you think that's going to deter them? It needs to sting. That is how you can get a ridiculous punitive damages award that will get upheld. And there's some recent case law that's basically upholding some very, very high numbers. Carney Shagirian, David Burgis, a few of these employment law, courtroom, Arsh Hamanpour, these guys are just absolutely killing it in that because they're not settling a case cheap. They see the big picture, and they're gearing up for trial to get justice for their clients.
That is a fantastic way to end this show. You want it to sting, but you don't want to kill them. It's been a pleasure having my expert guest, attorney Michael Burgis. For my guest, my name is Steve Appel, and this is Work Comp Videos. And that sounds great. Thank you in the radio podcasting audience for listening. We've got one more segment to go, and that will end the radio show, obviously, or the radio podcast. Obviously, we are running late, extremely late. So here we go with the last segment in 3, 2, 1. Thank you for joining us for another edition of Work Comp Matters Videos. This episode is with applicant attorney Michael Burgis, and we're talking about trial technique, how to get yourself a successful findings and award from start until finish. Mike, take it away.
All right, kind of a broad topic here. I'll just talk about little things that pop in my head here. First off, somebody gave me a bit of advice early in my career, and I really took it to heart, and it's paid huge dividends for me. And they said, Mike, try everything. if you don't get what you think is just for your client, just take the case to trial. I would advise all the listeners here to really, you should gear every case up for trial as if you were going to trial regardless.
I could not agree more. I never take a case without preparing to go to trial. Yes, my preference is to settle for a reasonable amount, but if I can't get in that range, I am prepping that case for trial.
Of course, and defense attorneys aren't dumb. They know who goes to trial, who doesn't.
That's right.
And not only that, they can tell a case that's being prepared for trial, what's substantial medical evidence, what's not, what holes are in there. And listen, you show up to court and you're not prepared, or you show up to trial and you don't have exhibits tabbed, ready to go, the defense attorney smells blood in the water. So you always have to gear your cases up for trial. You always have to be prepared to try the case. And I will tell you that if you gear your case up for trial, 99% of those cases are going to settle the day of trial, if not before.
Well, isn't it true that 90% of all cases, regardless of the type of action, settle, and then those that go to trial, 90% of those settle on the day of trial?
Those are probably pretty close accurates. I think I'm a little bit more litigious, so I tend to go to trial a little bit more than the average statistic.
You do have a reputation for trying more cases than the average workers' compensation attorney.
Which is why my clients get more money than other...
I'm not saying it's a derogatory thing. A fact is a fact.
Yeah, I'm just of the opinion that, like I said, I'm a big statistics nerd. I look at what the offer is. I look at what my F&A, here's the thing. I envision what the F&A is going to look and what the basis the judge is going to do to issue the F&A. And then I frame the case in a way that makes it easy for the judge to award it and issue that F&A. So water flows through the path of least resistance, right? And judges, like anybody, have a lot, they want to do...
They don't want to try cases.
Yes, I'm trying to think of a politically correct way to say this.
A judge. Why would a judge want to try a case if he's got to take the time to do it? Then he's got to take the time to issue the summary of evidence. Then he has to write the opinion. Then he has to worry about an appeal, and he has to answer the appeal.
Of course.
I mean, part of a judge's job is twisting arms a little bit to convince the parties to settle. That's part of a judge's job.
I don't disagree with that. And I don't actively seek to try cases because I don't get paid by the hour. I don't want to be caught up.
I would much rather settle.
So of course, but I gear all my cases up for trial. And when I say water flows the path of least resistance, what I mean by that is the judge knows who's prepared. The judge knows who's good. The judge knows who, if they don't find in favor for them, is likely to recon with success versus who's likely a soft target. And I will tell you that if you're prepared and you gear your case up for trial and you show up at trial with your exhibits, nobody should wing it in trial. Even me, who I've done lots of trials, I still have a full outline. Sometimes I don't, specifically write out my questions, but I have a full outline because, you need to become, you need to go in there prepared. And then ultimately, there are cases that I have.
I'm sorry, Jared, the IT guy was questioning us? Rewind to 10 seconds. Well, I would just tell you what, I'm just going to come right in. Michael, you've mentioned about 3 times now about being prepared, and I couldn't agree more. I was taught a long time ago that it's more important to know what is and what is not in your file than knowing the law. That's part of being prepared. And number 2, my father, a 30-year applicant workers' comp attorney, always told me about the 3 Bs. Begin, be brief, and be seated. I'm referring to questioning witnesses now.
I love that. I remember that the judges are busy and they don't want to hear you conducting a deposition, especially with irrelevant questions. What I do is I look at my steps and issues. I say, what are my issues? What do I want the F&A to say? What evidence do I need to provide the judge via medical evidence or testimony? And then I'm very quick. I'm very methodical.
I am very quick also.
You ask the questions, you get in, you get out, and then the burden will shift to defense to try to unravel some of that stuff, and then you do what you need to on cross. But I'm very methodical. I get in, I get out. I come prepared. Trial briefs, by the way, I'm a big proponent of trial briefs, even though it's a lot of work. there are certain ways, certain things that you need to argue and bring to the attention of the judge, and you can't effectively do that via medicals or testimony. And sometimes you really do need to do a trial brief. And I'll also say, when you show up with a very well-written trial brief, that is also a strong indication to the judge that can easily be converted to a petition for reconsideration. But and I don't mean that in a threatening sense, but in also it helps with, if you providing the judge the authority, it makes it easier for him to find for you. So you are becoming the path of, you are not the path of least resistance. And then the judge sees very quickly, like, hey, you're helping him formulate the F&A, and you've put in the time and effort. So some people ask, I have a very successful trial rate, a very successful appellate rate, and I'm batting 1,000 on writs, and I've taken a significant amount of these both on both sides, and I've won every single one, partly because my wife is such a brilliant writer as well. But it's I put in the time and worked my ass off, because I don't care how good you are, how many trials you do, you still need to know the law. You still need to know the facts of your case.
You can never be prepared enough. Last thing. Sometimes I take a lot of time preparing a witness, and other times I hardly take any because I want that spur-of-the-moment thought. Last question. How much time do you spend preparing your witnesses?
It's a good question. One, as most applicant attorneys, it's usually a high-volume practice. We're only making 15%. If you spent significant time prepping your witnesses, it's going to be a hard business model to be profitable and deal with your other cases. But the answer to that question is it depends. It depends on the client. It depends on the facts
of the case and the client. And I'm going to ask you one other question. 776, when you call one of the defense witnesses on direct adverse witness, how often do you do that, and why do you do that? And then we got to close it out.
I do it. It's I love when I hear people that do that. I do it when...
My father always said the only time he would call on 776 is when he knew what the witness was going to say, because the golden rule is you never ask a question that you don't know what the answer is going to be.
I do it when I know what the answer is going to be, and I know the defendant hasn't had the opportunity to prep their witness, and they're there.
How do you know that the defendant has not prepped their witness?
You don't, but it's an educated guess.
A gut feeling.
Yeah, and generally, you can see attorneys who are prepared or not.
Absolutely.
But when I think there's something that's important to get out before they've been adequately prepped, I do it. But the truth is, the vast majority of these cases, you don't need to do that, because as long as your client is credible and credibly testifies, look, all the cards are stacked in our favor. You got Labor Code 3202.
We only need 1% unless it's a cite claim.
Yeah, but that's a clever thing, and I have used it. And I will tell you, there are times that I've strategically withheld putting evidence in my case in chief because I knew the defense was going to lie, and I wanted to
get it in on rebuttal.
Exactly. Like, for instance, homeowner. I do a lot of UEF trials, and I have homeowner policy investigations that I don't list, and then I let them lie on the stand. And I was like, well, really, that's not what you said during the insurance investigation. You throw that out. So there are some clever things you can do, and a little bit of gamesmanship, and that's all has its time and place. But for the most part, you just be prepared. I try not to represent clients that I don't 100% believe. So the truth is, I'm always pretty confident in trial because I'm representing a legitimate, injured worker. And if I smell any BS, I usually get rid of that case quick, and I'm not at trial in that case.
What a great way to end the segment on trial technique. My expert attorney, Michael Burgis. My name is Steve Appel. You've been listening to Work Comp Videos, and we will see you during the next show. And for the radio audience, it has come to the end of another Work Comp Matters. This has really been exciting, and I really appreciate all the help that everybody has given me. For my chief of staff, my right-hand man, keeping me in check and out of trouble at least 90% of the time, Dr. Michael Zyma, the best-dressed man in California workers' compensation, Mr. Ted Durden. On the board, taking care of the technical difficulties from Uncle's studio, Mr. Scott Walton. Back in Munich, Germany, John Scalia, and, of course, all the fantastic people back at Work Comp Central that continue to support and approve of this valuable project, including, but not limited to, Leaf File and Kristen Chavez. My name is Steve Appel. We'll see you again next week week on another edition of Work Comp Matters.